You've heard the old saying, no good deed goes unpunished.
Yes.
Well,
yeah, that's it. That's a shining example right there.
All right. I don't know exactly what he was talking about, right? And I don't know exactly what's going on in his mind, but I know how it sounds, and I know how prosecutors are going to use that against him. I mean, he's in jail because an unarmed young man who was jogging through his neighborhood was shot and killed by his son. And he was kind of the leader of the whole posse. And they're kind of laughing about it. It's all recorded. Now the question is, should all this get in front of the jury in his trial? And my guess is it may very well end up that way. But let's get some more information. Joining us tonight from Brunswick, Georgia, Court TV legal correspondent Julia Janae joins us. Julia, great to see you. So prosecutors would like to use that phone call. Are there any others that they want to use as well?
Oh, just 1,500 jail calls, Vinny, in the year that all three of these defendants were incarcerated. That's how many calls the state has in their possession, and they've turned over to the defense. And what the defense wanted was to get a blanket order from the judge saying that they can't get in any of those calls. And they used a really unique argument saying that there's a constitutional protection on these calls, that there's a legitimate expectation of privacy, even though they are recorded, but the fact that they weren't doing any criminal activity on those calls, that they should not be subject to being used at trial. They allege due process and equal protection under the law and spousal privilege, but ultimately that's how many calls there are. We don't know exactly which ones the state wants to use, but that one about no good deed the state has already used before in a bond hearing.
Right. And here's the thing. Okay, the judge will make a decision, and we're going to listen to some of the arguments that were made in just a second. But at the end of the day, I mean, Greg McMichael he worked in the DA's office, right? He was an investigator. I mean, he understands all of this, and it's very clear that the stuff is being recorded, and I think he would know that anything you say at some point that's being recorded by the government may very well end up being used against you. I mean, was there any argument made by the defense or anyone that somehow he didn't know that or realize that?
No defense that he didn't know that they were being recorded. I mean, there's a recording at the beginning before the call even starts that says that this is a call that is being monitored. It is being recorded. So it is very clear to both parties on the phone that this is being recorded. How he didn't know that it may be used against him, I think is very hard to say. But we know that he was even trying to keep the things that he was doing in jail coded in the way that he responded in some of those calls. And there's a letter that he sent out to one of his friends that is completely written in what looks like hieroglyphics and code. And again, something that the state used to tell the judge that he did not deserve bond, and he still is behind bars.
And we've seen things like this before. You know, the George Zimmerman case, this was another example. And his wife, who became his ex-wife, because George Zimmerman allegedly was stepping out on her while he was living in his father-in-law's house. Another story for another time. Anyway, there was also that coded kind of thing going on, and his wife ended up getting in trouble for it. And I understand George Zimmerman, not very sophisticated, never a member of law enforcement. But for McMichael, it really surprises me. And yeah, you can speak with your loved ones, everything else, but keep the conversations focused on, like, I miss you, I love you, this and that. You're talking about the case, to me, is inexplicable to a certain extent. Anyhow, let's take a listen to the arguments that were made in court today about why they should not be permitted in front of the jury.
What's at issue in the motion is that when a law enforcement agency or prosecuting arm of the state, or in this case even the federal government, but our concern is the state, requests those jail phone calls from inmates, that's what the motion addresses. I've got 4 arguments against the admissibility of these phone calls at trial. First one is due process under the 14th Amendment of the United States Constitution the clause that says, "No state shall deprive any person of life, liberty, or property without due process of law," and with conditions to whether pretrial detention violates that constitutional protection, namely the deprivation of life, liberty, or property without due process. We ask, do those conditions of detention amount to punishment? Argument 2, still under the 14th Amendment, is the Equal Protection Clause. Here the 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. So if you compare defendants charged with murder, there are those charged with murder who have been granted bail and are out on bond. Then there are those who have been charged with murder who have been denied bail and are in jail. The third one, I will say, applies only in this case to Greg McMichael, and that's the spousal privilege. The last argument I have against the use of these phone calls is the Fourth Amendment. Now, I will concede that the case law is mostly against me on the Fourth Amendment issue, but I want to point out one toehold that I believe does give us an argument, at least, for the court to consider and rule upon. No inmate has a legitimate expectation of privacy in phone calls in which he is engaging in illegal activities on that phone call. But that doesn't mean he can't have a legitimate expectation of privacy in conversations with others who are not his lawyers and not his spouse about his pending case.
Another thing that came up in Deputy Britt's testimony is the fact that this is a privilege when you're in jail. They're not required to give you access to telephones because you're confined pre-trial. And there is absolutely no right to talk on these telephones at jail. It's a privilege and a courtesy given to defendants. Some defendants choose to use it, while other defendants choose to not talk on the telephone. Thus, the jail calls should not be categorically excluded based on due process grounds. Also, we don't believe there's an equal protection issue here. The Due Process Clause and the Equal Protection Clause of the federal and state constitutions, they protect only rights. They do not protect mere privileges. And we contend that that's what we have at issue in this case. There's actually a case, Woodard v. Lawrence County, site 265, Georgia 404. That's a 1995 case. And the court there said that the due process and equal protection clauses only protect rights. They don't protect privileges. And here there's no right to jail calls. There's just no right at all to it. It's a privilege.
Interesting argument. It may not be the right to the phone call, but the right to the conversation, maybe the way the defense would come back on that. But the spousal privilege, I would think would go away if you know that someone's listening to your conversation, right? Isn't it supposed to be communications that other people aren't listening to, but if you allow someone else to listen to it because you know someone's monitoring the call, then maybe you waive that spousal privilege. I don't know. Just spitballing here tonight, Julia. So where did the judge leave it on this issue today?
He left it where he left most of the motions that we've heard over the last 2 days, and that's he's taking it under advisement. So he's heard the arguments on this issue, and he will likely write a written order that we are going to be paying attention on the docket to see what he decides on that request to exclude all the jail calls. Okay. And it's not necessarily a super easy issue. I mean, the defense has come up with some legitimate arguments, and we'll see what the judge does. More arguments today about the mental health of Ahmaud Arbery and whether that should come in. Let's take a listen to those arguments.
The experts' conclusions lacked sufficient probative value and thus were inadmissible under 403. Obviously, we are not there yet, but my concern is that Mr. Sheffield just told the court that one of the things he wanted was to put his doctor up in order to have you listen to her as part of the ongoing sealed sort of package. The state would object to her at this point testifying, given we're bifurcating this issue. So the court, though, however, the state wishes the court to be aware that 403 analysis is an appropriate analysis to conduct, because in this case, the court said, because of the rather raggedy patchwork of sources that the person had to deal with, I will direct the court to the raggedy patchwork of sources. These sources are Mr. Arbery's worst days of his life. Absolutely the worst days of his life when he is involved in law enforcement. This is not every day of his life. And to have their doctor come in and go, well, I looked at all this stuff and it supports a conclusion based on a 2-hour form that got filled out as a diagnosis, the state contends that's a raggedy patchwork of sources that their doctor had to work with, because their doctor never ever met Mr. Arbery and never talked to him on his best day.
The state has chosen to get into the mind of Ahmaud Arbery suddenly and say, well, these are just his bad days. These are just his days over the course of 3 years, which shows a very sad decline based on mental illness. And because he has had this decline in the presence of cameras and other people, then it's been captured. And then, of course, we should use it to analyze whether it fits within this idea of mental illness and relevance. It would be error not to consider this evidence because it comes from reliable sources, well-meaning people who are either trying to do their job or protect their community and have an interaction with Mr. Arbery.
All right, Julia, put this again together for us. What exactly does the defense want to do with this issue of Ahmaud Arbery's mental health?
I'll start out by saying the judge wants them to narrow down exactly what they want to do and which records they want to use. But ultimately, big picture, they have these records from Gateway Behavioral that they say show a diagnosis of schizoaffective disorder, that it would lend to support their theory that Ahmaud Arbery on that day was acting angrily and aggressive because someone was chasing him and trying to hold him responsible for something that he was doing. They believe that these records will help the jury to understand what was happening, what his reaction was like, and their argument that he was the primary aggressor in that confrontation with Travis McMichael. The state obviously saying that using those records would actually be against public policy in allowing someone who's been victimized to then use their medical records, specifically their mental health records, against them. That would discourage people from talking freely with their mental health provider. So the judge really wants them to get much more specific about what they want, how they want to use it, and how the law allows that to be relevant.
I'm glad the judge wants them to be more specific because I do also, so I can understand it a little bit better. But great job, Julia. All right, let's get to the final thing I want to talk about tonight, which was a little back and forth, a little questioning by Kevin Goff, the attorney for Roddie Bryan, the man who recorded everything on his cell phone. And apparently he was interviewed. They want to get some of those statements out of the trial. Let's watch the back and forth here.
Do you recall telling him the problem was that the GBI director and the DA were uncomfortable at that time saying publicly that Roddie Bryan was just a witness?
That was towards the end of our interviews, and that was after the time that you had scheduled a press conference without us knowing about it.
Without you knowing about it? Okay. Do you recall joking with Mr. Bryan in your vehicle before turning on the recording device that the video was made with, when Mr. Bryan asked you yet again whether you were going to prosecute him or not?
No, sir.
You don't recall looking back at the other officer in the car and laughing about it like it was silly?
No, sir.
Okay. And you never did anything to reassure Mr. Bryan that if he cooperated with you and told you the truth, never at any time did you suggest to him that he would not be prosecuted?
No, sir.
All right, Julie, it seems like the allegation by Kevin Goff and Roddie Bryan is that they were misled by investigators.
That is the allegation. This is part of a motion to suppress statements, the things that Roddie Bryan said to investigators in the interim after Ahmaud Arbery's death, after the time that the GBI took over this investigation, and then after the arrest of the McMichaels. But there was a delay in arresting Roddie Bryan. About 2 weeks had passed. So overall, his argument is that these investigators misled him, meaning that these statements that he made were not voluntary. They were involuntary because he believed he was going to get some kind of benefit for being a cooperative witness. And we know the outcome was he was then arrested.
Okay. More legal advice, folks. What you say can and will be used against you. That's the bottom line, unless you get something in writing to the contrary. Okay. Julie Janae, great job down in Brunswick, Georgia. Appreciate it. Thanks so much.
Thanks, Vinny.
All right, when we come back, we're going to take you out to Minneapolis. Big developments in the case against the other 3 officers accused in the murder of George Floyd. Chandler Painter will join us live.